All right, let's get this party started. We've got a number of questions online, and I want to thank the best legal team, even though they are from different firms, but the best legal team for CCI here, agreeing to come out on this cold day. So on the panel is Victoria Archer, who's with Glenhill Little Rock, and Victoria Archer is a specialist in condominium law, has been around since the 90s, and is that too? Okay, should I change that?
Yeah, change it.
Since
we'll talk afterwards about changing the whole thing.
She started her practice when she was 25, so there you go. But Vicki Archer, of course, is amazing on the condominium file and has been a real champion for owners and condominium boards. Assisted with the Act changes and input in 2000 and now again 2014. Next to her is my arch nemesis, Todd Shipley. He is a lawyer with law firm here, RMRF, Richards, Mirth, Farmer, and what did I do?
You just butchered that.
I just butchered that. Let me do that again. RMRF. Let's just call it that. Reynolds, Mirth, Richards, and Farmer. And so he's been a longtime lawyer here in the Edmonton area. Next to him, principal at Willis Law, is Hugh Willis, joining us today.
Thank you, Tom.
And a prominent lawyer here, been involved with CCI, as you know, for many, many years. So I will now get to the questions. Thank you all three for being here. We've got a number of questions that were sent in, and we'll take questions from the floor. I'll start off with a couple online. A very straightforward question. What is a conflict of interest? And this person gives an example. Board members who rent their units vote on a motion about security deposits. Is this a conflict of interest?
Sorry, the question is, board members vote on a motion regarding security interests and they are landlords?
Yeah, exactly. This board member who rents their unit votes on a motion about security deposits. Is that a conflict of interest? So they sit on the board, they have renters, they have voted on the security deposit, whether condo corporation is enforcing that or not.
No. Do you want to give more detail?
The Act refers to a material interest, not a conflict of interest. And when you look at what a material interest is, it is you benefit personally from what is being discussed, and your benefit is greater than that of just being an owner. So if you are an owner who rents out his or her unit, and you're talking about security interests, you are not receiving or losing any greater benefit than any other owner. I do not see that as a conflict of interest.
Yeah, the only way I would see that as a conflict would be if the discussion was whether to use that specific unit's security deposit based on an incident.
Okay. What can you do when your board will not provide information like a reserve fund report at the annual general meeting?
First off, the corporation is not required to give out a copy of the reserve fund report at the annual general meeting. So it's not required to. It probably won't. I've never seen a corporation do it. What the person may be referring to is the annual reserve fund report, which is an entirely different document. What I can say is the condominium property regulation and the Act require this to be given out. If it's not being given out, I would say there's probably a couple of reasons. Number one, perhaps the board and the property manager do not realize that they have to provide it. And a couple of years ago, there was a change in the regulation that made the annual reserve fund report more complicated than it used to be. Often corporations and property managers just say, well, it's included in the financial statement, so we don't do a separate document. Now it is a separate document and must include more information than would be in the financial statements, because now it also has to go on looking at the present fiscal year. So first off, if they're not providing it, ask them to, and tell them it's required by the Act and the reg, and if necessary, look up your section numbers and tell them. If they then refuse to do it, then come speak to one of the three of us, or the dispute panel if we ever get one.
So building upon that, some a little bit more, I totally agree with everything that Vicky said, but a little bit more practically, ask nicely. Don't berate or threaten them, and you can ask nicely by pointing to section 20.52 and saying, I understand that I'm entitled to this information under this section, and there's 10 days, but I look forward to receiving it. It's amazing how well that works. And if it doesn't work, there are remedies. Unfortunately, the remedies that we have are a blunt hammer under section 67, but it usually doesn't have to get to that point.
And run for the board. If they're not doing something that they're supposed to, put your name forward. Step on the board and help be the solution. Everybody should take their turn on the board at some point. But at the same time, as we've talked about many times, every condo has at least one owner who should live in a house, right? But if they're not providing a document that they're required under legislation, another practical solution would be is to step forward yourself, sit on the board, and help change that for the next year.
You notice that Hugh did not use the appropriate terminology, which I've trademarked for that individual, right?
Yes.
Net bar.
Yeah.
All right. All right, we're going to move on. Go ahead, Darcy.
What about requests that are outside of section 20.52? And they want to see contractor invoices, they want to see contracts.
Yeah, I'll start with that one. So the legislation at section 20.52 has a whole laundry list of documents that a person is entitled to, and the corporation must provide. And then in bylaws, sometimes there's language that says you are entitled to the books and records of the corporation. Older bylaws that refer to books and records, that's often pre-accounting software. And it was the idea just to prove that the corporation was actually keeping some sort of financial records. But if we haven't updated our bylaws, that's still there. And there seems to be some owners who are using this as a fishing expedition to try and go out. And I don't know if they're wanting to look at last year's snow removal quotes because they have a competing business, or if they want to become the cleaner, or if it's simply a fishing expedition to try and find fault for a particular grievance with the board or whatnot. Amend your bylaws, be transparent. They're entitled to the information in 20.52, possibly certain books and records. And if your bylaws refer to that phrase, books and records, I would suggest you talk to your auditor and get a clear definition of what those specific documents are. But at the same time, they're not necessarily entitled to other people's personal information or details that way either. So it's not a free-for-all to run through what the corporation has historically.
Now, sometimes, I would answer this one, building on what Hugh just said, with it depends. It depends upon the nature of the document. It depends upon who's asking for, what the purpose of it is. Is this part of a problem where some people they're getting upset over some things they don't like, and my brother-in-law can do it cheaper kind of a thing, and so they're just causing problems versus a legitimate question. And so what I will often tell a board is that here are the obligations, but if you want to release more, that's a board decision that the board can do. And then it just comes down to a whole series of things you need to carefully look at. While you're looking at the next question, there was a question about PIPA and about asking CCI for, let me see a copy. With any type of precedent like that, just be careful, because a privacy manual needs to be specific to your building. Specifically, do I have surveillance? Yes or no, right? How are we set up? One of the things you can do that's helpful is, in addition to asking other condo corporations or CCI, actually contact the Office of the Privacy and Information Officer in Alberta. They're the ones that if there's complaints, they actually have a number of cases where they've dealt with privacy issues in condos. In my experience, is that they're actually a great resource in putting together something for your corporation.
Okay, I've got a number of questions. I'm going to rapid fire. Any doorbell doorbell cameras or personal security cameras an invasion of privacy in condos?
Well, I would say that would depend. If it was in a condo I lived in, I would consider that an invasion of my privacy. If they were private doorbell cameras. Perhaps other condos don't, and perhaps other people don't care. I think it's something that condo corporations, not just the boards, but the corporations have to take a careful look at. Is that type of security in the hallways, needed or wanted? And then look at parameters for, if it is, how are we going to do it? Are these going to be cameras operated by the corporation where the corporation has control over who sees the tapes, under what conditions they're viewed, and how they're kept securely? Or whether people are going to be able to install their own doorbell cameras or outside door cameras, and if so, what about the wiring? What about the size? What about the location specifications? Would it be an invasion of my privacy if my neighbors did that? Yes.
So it depends. For example, does the doorbell camera look at a wall, or does it look at someone else's door? Right? That's the first thing I would want to know. If you had to distill down the Condominium Property Act into a word, one of the ones that would leap out at me would be fairness. And when you look at Section 67, which deals with the remedies for improper conduct, one of the things that it meets the definition of improper conduct is unfairly disregarding someone's interest. And so, I just had a question come from a board about dealing with an age restriction in a bylaw. And instead of just pointing them to the answer, I said, sometimes the answer is how you go about it as a board. That's just as important. So in this situation, I think if there's a request for a doorbell camera, that the board would be well advised to listen to and ask the person who's requesting it, what are the reasons for it? And then also ask people on the same floor, if they're on the same floor, what are your thoughts on this? And so that way they're regarding everyone's interest. And if at the end of the day, they make a decision based upon polling that, it's much more likely that that would be supported because it shows that they're being reasonable and prudent and trying to be fair.
I guess I take maybe a bit different approach, and I think the circumstances are different if we're apartment style versus townhouse. I think my willingness in a townhouse would be much more liberal, but I guess my starting point is if someone feels threatened, I think the corporation should tread lightly in terms of if they want to add an extra deadbolt or extra security feature or a camera in that circumstance. And if their particular circumstances, they've been a victim of stalking or domestic abuse or something like that, and they're worried about that, then it's something to take in consideration. But the key message, I think, from all three of us is it depends, and you need to look at a specific or site-specific circumstance. Certainly, asking for one on the third floor of an apartment style, strange. So certainly wanted to peel that layer a couple more layers deep to see exactly what the circumstances are.
Okay. All right, let's go to a question about, that's way too complicated. So let's go to this question. What help is available to a board when the unit owner leaves an unstable tenant in the unit and chooses not to respond to board communication about the tenant's activities?
I don't know that that's ever happened.
No, never.
That's a challenge. So under the Condominium Property Act, the board has the ability to remove a tenant, notwithstanding any terms of a lease or a residential tenancy agreement. It's sections 53 through 56, I believe, in the Act. But you have to have a certain situation. You've got to have either non-compliance with the bylaws, or for more serious stuff, threatening physical violence or damage, then you can speed it up. What the board can do is they can serve notice on both the tenant and the landlord that the tenant has to be out. by the end of the next month. So if you serve them on August 31st, they got to be out at the end of September. If you serve them on September 1st, they got to be out at the end of October. If it's more serious activity, violence, etc., then you can try to do it on 24 hours notice, but it would involve a court application. So what I often tend to do is encourage the boards to try to work with that landlord and get the landlord to do it. And even if the landlord is sort of going down that road, I always say give them the notice, because it gives you flexibility to remove them. But it can be a challenge.
I'd like to add a little bit to that one too. This question used the word unstable, and I'm not quite sure what that means or in whose opinion the person is unstable. But if a person is causing some issues because of mental disability, then suddenly we're in the potential human rights realm. And when we are in the potential human rights realm, then the duty to accommodate clicks in. So it can be a very difficult, tricky situation to deal with. And depending on the circumstances, the board may find itself in the position where it cannot evict a tenant because someone else thinks they're unstable.
And I'll jump in. I think it's a good message or practice, I guess, to stay on top of your landlords, to get their contact information where they can be served in the name of their tenants as they're required to do some legislation. I've had a circumstance where we've had to evict the tenants, and the owner was out of country, and serving that and dealing with that part of the court process so that we could actually deal with the merits of what was actually happening. I think part of the evidence we filed in court was they were putting broken glass inside the common washing machines in that file.
Wow.
But there was some procedural difficulties because we couldn't locate the owner because they were off continent actually. And ultimately the court was able to grant us the relief we needed, but and we had a strong manager on the file, but it's one that you don't necessarily want to enforce. But if you make it a practice that we are enforcing it every time you're a landlord, where do we serve you documents? What's the name of your tenant? And actually be diligent in pursuing and taking a firm line on that. I think in the event you have some of these challenges later, it just removes some of the obstacles to dealing with.
Building on Vicky's comment about human rights, we're handling a matter right now where a tenant comes in. It was a restricted pet building, so she applied to come in with her cat, small apartment, it was approved. Moved in with her cat, and I can't remember the name of the breed of the cat. Oh yeah, it's German Shepherd. And then all of a sudden it was like, no, you can't be in here with your German Shepherd cat. And the response was, well, I've got like PTSD and such and depression, and my therapist has issued a prescription for a German Shepherd cat. And it's actually in front of the Human Rights Tribunal at the moment. Good times. Not that there's anything wrong with a German Shepherd cat.
Did you see the article on the emotional support alligator?
No.
Have you seen that? Google it. It's in like Philadelphia or something like that. The guy has registered an emotional support alligator. And I told my colleagues at the office that if we ever see that in Alberta, I'm done. I'm out.
Hugh, I've dealt with snakes.
All right, we have a question. When a unit is occupied by a first-degree relative of an owner, parent, or child, do they have the same status as renters? For example, if the corporation requires a damage deposit for rental units, would they be exempt?
So no, they would not be exempt. The legislation, when it was amended, was specifically worded as the lesser of 1 month's rent or $1,000. Furthermore, the legislation defines owner, so there is a definition of owner in the legislation as the person registered as fee simple. So if they are not on title as a registered owner, I believe they're a tenant. Possible wrinkle maybe if they're a spouse, but otherwise I think a damage deposit is required.
I am assuming that the question doesn't mean that, for instance, a mom and dad have a niece or a nephew moving in. I'm assuming that that first degree relative is living there all by themselves without the unit owner there.
the language, as Hugh said, was changed to make it a little bit easier. It used to be a little bit trickier when we were dealing with this, but even if you couldn't follow, or they argue that it doesn't fall within section 53 and 54, you have the abilities to deal with this under section 67 if someone's causing a problem.
Yeah, and often we get, when we're doing bylaw revisions, people are like, well, we want to limit the number of renters, like we can do in British Columbia. You're not allowed to do that in Alberta. But when I talk to just look at my own files and talk to folks at our office, I don't necessarily have more problem owners or problem tenants. The one group that's identifiably higher problematic for their behavior is son or daughter of owner. Because the rules don't apply to me, my dad won't let you sort of attitude. And that seems to be sort of the one group that we see, if there was a distinguishing factor of one group more than others, that was the one that certainly I recall.
Okay. I'll ask if there's questions from the floor. Please come up to a mic and we'll get to those as well. I've got a real quick question about when selling a condominium unit, is it necessary to obtain a real property report?
It will depend on the agreement to purchase. Most agreements to purchase require a real property report if it is a bare land unit. But that's most.
Okay. Do you have a question? Go ahead.
Yes. Corporation has a request and undertaking for someone who wants to make changes to their unit. Will that request undertaken follow the unit, or does it follow the owner? Because the corporation also has a caveat clause, restricted covenant, that they may file a caveat against that change. So the thing is, what's happening is requests and undertaking are provided, and the corporation or the board of directors says that that's adequate to cover any future owners if they sell.
So let's use an example. Somebody wants to put in a solar tube or a skylight or replace the railings on the deck, which is common property, with glass railings. And they say that they'll be responsible for it. I'm interested to hear what these two say, but I would say the problem with that is I don't think that you're going to be able to enforce that against subsequent owners because it's common property. And if you allow someone to change or amend the common property, it's still common property. And under section 37, the corporation has the responsibility to repair and maintain. So you may have a situation where you let somebody make a change or an upgrade, but if there's a problem with that, you're going to have an issue with subsequent owners. You also potentially could still have an issue with even enforcing against that person, depending upon how strong the agreement that you have worked out actually is.
I think there are some ways you can put in to help safeguard the corporation, but I agree with what Todd is saying. There's the provisions there with exclusive use areas. Is it an exclusive use area, at which point the owner can be responsible? There's a few things that might be a benefit, but basically, if you make a personal agreement with one person, you can enforce it against that person, subject, as Todd said, to, if it's now common property, if it's become common property because you allowed them to alter it. Now, you can have a clause in the bylaws, something about, any additions or changes made by current or future owners become the responsibility of the then owner, which would help. But there's nothing there, I think, to 100% safeguard the corporation if it allows people to make changes to the common property.
And I'll jump in specifically on the bylaws is for example, a deck. Person has a bigger deck or a landscaping feature, because you want to avoid the surprise for future owners. Suddenly they see this great feature, they think the corporation's paying, then they find out it's them, and it's the first thing they hear. Really sets up a negative relationship with the corporation. But maybe some bylaw language that says that if this feature is granted, any costs are assessed only against that owner, or that it has to be restored back to original common property, original circumstance, by the owner upon selling the unit, unless the new owner agrees to be responsible for it, and having some specific bylaw language like that.
Okay. All right, now we have a question about condo management accountability. So how do you keep a management company accountable for their contract when other condo board members don't seem to care?
You don't.
I think you raise your concerns to the rest of the board. You know, you can't just sit there and stew and figure, why isn't it fixed, if you don't say.
Yes, you can sit there and stew.
Well, you
That's one of the
shouldn't.
rights of board owners as well as board members, to sit there and stew.
To be effective or make effective change, you need to
Okay.
communicate your concerns. But it's made by board decision. In order, and also when you're stating your concerns, make sure they're valid. Many people require the managers or want the managers to do things that are not covered off in their contract. And it's just not part of the management arrangement, but they think it should be. So just make sure you're on good grounds before you raise those concerns. And again, communicate with the property manager through the board if that's your route for communication. Sometimes it's just a communication, oh, we'd like you to do this. And sometimes it's more than that.
You know, another strategy might be to schedule a meeting. Don't do it at a regular board meeting, but have a separate standalone meeting where we want to have a dialogue with our manager about, you know, your contract and whether, you know, how we're feeling about it, but how you're feeling about us as well. And don't tack it on to the end of a meeting because it just becomes a complaints department. But if you have that dialogue and you do it the right way, it could be really productive. Be prepared to get it back though. Okay, like if you're going to do this right, it's not just putting the manager up there on a block to have repeated shots at them. You need to hear back from the manager as well, saying, okay, by the way, one of your owners is emailing me 60 times a week. So I've got this many hours I can spend on your property, but we're dealing with this sort of issue. Or one of your board members is emailing me 60 times a week. Can we tone that down? Yeah, you know, but have that dialogue. It could be a strategy to try and for a solution, but you know, if you're going to be critical, come with solutions. At the same time, be prepared to hear some stuff that you might not be comfortable hearing.
Okay. Love these developer questions. Does a corporation have any recourse if a developer has only built the first phase and has lapsed in building the second phase of the corporation, leaving the builder with 50% of the unit factor's voting rights when the second phase was to be built 2 years after the first phase and has no immediate plans to build the second building? Did you follow that?
Yes.
Okay.
So what we're talking about is phasing. The challenge though is there's two types of phasing. There's legal phasing, which has specific remedies under the regulations of what happens within a certain period of time in the event the developer doesn't go ahead. And then you have, call it soft phasing, or what we call barely blended, which doesn't have those protections. So the first thing that you need to do is you need to take a look at, are we actually in a true phase development? And if that's the case, and there are specific remedies that are available, which would end up kind of leaving that development is a little bit of a standalone. But again, there's a certain, I can't remember off the top of my head how many years it has to be before they're not doing it. But if you're into the kind of the barely blended approach, then you might have a bigger problem. But you will have a bigger problem.
If you're not sure if the condo is phased according to the regulation, as Todd was talking about, or just one of these barely blended redivision of bare lands, check the CADs. If it is a proper regulated phased development, there has to be a phased development disclosure statement registered against the condominium plan, and that gives you all kinds of information about how long the developer said he's going to take to finish it, what are the voting rights, what are the financial implications, and all that kind of stuff should be on that statement. So that's a good place to look, to make sure it's the regulated phasing.
So I have one where the phasing statement was in the contract. The contract specifically provided it was phased, but it wasn't actually registered, and they were doing it that way. So look at it carefully.
I've got two questions. I'm going to combine them because they're about voting. So one, are board members now elected by unit factors? I was sure that ex-lawyer, I'm not going to say which name, said that there was no more acclamations, but our last 2021 AGM used acclamations. And I'll just build upon that. Please share information about board of directors elections where the number of candidates is within the bylaw requirements, acclamation. In brackets, I've been told acclamation is no longer allowed and a vote must be conducted for each candidate, but I do not see this in the legislation. I do note that the legislation requires for all votes to be recorded in the minutes in detail, number in favor and against, but that is for any matters that do go to a vote. If acclamation is allowed, is a motion required to adopt the slate of candidates via acclamation? There's more, by the way. Please be succinct in your question. Or no motion and simply required in the minutes that the board was adopted via acclamation.
So,
and if a motion.
Is it your president's report here or what?
Go ahead.
All right. So I think we got a couple of different things that are going on here. Now, remember, we've talked about this in the past, and we actually had some differences of opinion up here. First, in regards to acclamation, I've got 4 spots available for the board. 4 people have run, that's it. Are they your board members without even doing an election? My position is yes. Now, that said, you have to look at the bylaws, okay? Then you have a next issue which can come from that, in that you have 2 types of voting: plurality versus majority voting. And at this table, there's different perspectives on the utility of majority versus plurality voting. Plurality voting would be the top vote getters for those spots get in, full stop. Majority voting is the people that are elected have to have a majority of people that are elected them. Okay, so all 3 of us at this table have had some involvement in the last 2 years with one condo corporation where this issue came up, and it ended up being a court application because the bylaws reference Robert's Rules of Order, which talk about both, but they weren't express. And a motion was passed to do it by majority voting, which is everyone has to have a majority of people support them, and then someone challenged it. And it ended up being argued before Justice Ackrell. We were successful in defending the board, but it was unique and specific to the situation. What I will say about this is that look at your bylaws, and with the bylaw changes that are being done right now, it is entirely possible to structure your elections the way you want to. There are some there's some corporations where it's just the people that show up are in there, and if there's an election, it's the top vote getters. And that's kind of the culture. And there's other ones that want to do this situation where they ensure that the board actually has a mandate from the majority of people. If you want to go those ways, if you're looking at your bylaws, talk to your legal counsel and just make sure it's clear. You're going to avoid a problem. But again, I know that there's different perspectives on this.
I agree with what Todd has said. Bylaws are incredibly important. The other thing I'd point out is one of the things the advocacy committee is working on with the government right now is all of the voting requirements that are in the act. That was to have gone before the government, was it May?
Yeah.
I think it was in May, but that was of course tabled and is still floating out there. And we're not sure what's going to happen. So anything we talk about voting now might or might not be the case when the bill is finally passed.
From my perspective, I like the majority voting. I like the idea that owners get to vote yes for who they want, no for who they don't want on an individual basis. So in our bylaws, it's a recommendation I make for just about every site. For the reason that I find that one owner who may not recognize that they don't have the support for their particular agenda from the rest of the group is usually very well intended. And other people look, I don't want to sit on a board with that guy. But if you get the idea that, okay, you know what, I'm just going to vote no for him and yes for who I want, then I start seeing more people participate. I see the corporation stick handle around some challenges because these board dynamic disputes over mandates tend to escalate really quickly. Legal fees explode on both sides, and it's there's so many better ways to spend your money than if we can avoid that sort of fight in the first instance. Bylaws are the best way to do so.
Okay, we're gonna wrap up soon. Are there any questions from the floor? All right, I'm gonna give you, pick a choice. Do you want to deal with another developer question, or do you want to deal with suing engineering companies and construction groups?
Second one.
Okay. All right.
What about pets? Don't we have any good pet questions?
No, there's no pet questions. Everybody's happy with their pets. Okay. For almost 2 years, our condo corporation has been embroiled in a legal wrangling with an engineering company and a construction company that were overseeing during, or English, okay, they were overseeing during our very extensive rehabilitation. We sued both over very egregious deficiencies neither were accepting financial responsibility for. This has been ongoing for almost 2 years, and now our board has released, in quotations, the engineering company from the lawsuit to garner their cooperation in doubling down on the construction company for costs. Naturally, nothing has happened. Do owners have any recourse in this? What is the responsibility of the board with respect to this deal?
So I am not going to touch this one with a 10-foot pole.
Okay.
Because when you're dealing with litigation involving professionals and contractors, it is incredibly specific in regards to liability, breach of contract, negligence, etc. And I wouldn't want to say anything on this that could be construed as legal advice, and here's what a lawyer said at CCI. So myself personally, I'm not gutsy enough to take this one on.
I'll jump in on it and say that the COVID circumstance, we've seen the delays at land titles. Delays at the courthouse were similar. What we would normally be able to file and get a court date back within same day or next day, we're now, there was a time we were waiting, 6-7 weeks to even get a court date, let alone have it heard. So there was substantial pandemic-related delays that affected the court process, I think, across the province.
I love how Hugh did not answer that question while claiming that he was going to answer that question.
No, I said I'll chime in.
And
Didn't say I'd answer it.
I'm going to chime in as well. Just on my reading the subtext on this, it sounds like every party is lawyered up, and every party, including the condo corp, will hopefully be listening to and considering and taking the advice of the legal professionals that have been hired. If it was just a unit owner who put this question in, they probably don't know everything that is going on behind the scenes. Neither does the board need to tell them, neither should the board tell them, because that would be one of those confidential things. The board doesn't have to tell all of the owners at this point.
Okay.
And run for the board.
Okay, one last thing, because this question doesn't make sense to me, but it might be a soapbox to talk about the tribunal. So any updates on the provincial legislation bylaw review board?
So if it's a tribunal, there are ongoing discussions. Certainly the previous minister had made commitments that we would see a tribunal. Then there were some funding issues. There's still lots of work to be done. I think generally there is, not universal support, but pretty strong support. Some of the challenges we have to address is specific jurisdictions. So what can the tribunal do, and what should be left to the courts? Certainly in our case law and legislation as it stands right now, there's certain things that the court must hear. So is the tribunal going to try and move around that? But funding is another really practical model or concern, in this issue. I think the intent is for the industry to fund it, but how does the industry actually collect that money? Just for discussion's sake, let's say it was a dollar per unit per month. Well, does a condo corporation pay that? What if they don't? Who's going to go about collecting it? Is it something that would go on the municipal tax roll where there's an additional tax put on the municipalities? They don't want, from what we're told, any part of collecting that and administering that. So how do we go about actually having something that's properly funded? Because without the proper funding, if we launch this without having the resources to actually do it right, are we actually creating a benefit or are we making things worse? Another consideration might be, do we look at the provincial court because there's a mediation process there? Is that maybe another jurisdictional question? So there's lots that we still have to sort out, and the devil is in the details, but we're not at a point where there's anything we can drive. But those are some of the considerations we're looking at.
Recently, Hugh and I, a year ago maybe, we presented at a lawyers panel similar to this, but we're presenting to lawyers on condominium issues. And one of the things we were talking about was we were originally going to talk about the new tribunal, and they sort of canceled it. So instead, what we did is we did a review of the existing tribunals, and it was Nova Scotia, Ontario, and BC, and looking at their experiences so far. And I have always been not a rah guy about the tribunal. I'm not down on the concept, but I'm not up on the concept. And if I had to summarize my feelings on it, it will change things, and not necessarily always in a positive way for some people. The benefit of easy access to justice is easy access to justice. The downside is easy access to justice. There's a lot of things that are kept out of formal dispute processes because of the complexity and cost of court. When you make it so that people can take their beefs with minimal cost to a tribunal, they're going to do it. And so that will put additional pressure of time commitments onto boards and to property managers. And sometimes that can be a good thing, especially if it's one of those things that was very expensive going to court. To have it resolved in an economical way, fantastic. But if it's one of those other things, buckle up.
And third to chime in, probably the last, I agree with what Todd and Hugh have said. I will say that all of us here have been working for a number of years and intensively this year with the government and other stakeholders on this tribunal thing. It sounds good. We need a tribunal to have a time and cost efficient method of resolving disputes. And if you look at it at that level, great, rah, what's taking you so long? But as Hugh said, the devil is in the details. And as Todd mentioned, justice. Some of the suggestions, proposals I've heard around the round table that we've been sitting discussing this, I don't think will end up in justice for anybody. I advocate for condo corps and individuals at times, and I want something where all parties can actually look at justice, where not any one party is railroaded through. And, where the law is applied properly. And there's so many things that have to work out or be worked out before we can get to that point. I don't know how the rest of you feel, but I'd say don't hold your breath for this tribunal. There's still a lot of work to do.
Yeah, and I think with the change in premier and shuffling of ministers and the election in May, I'm not optimistic about our timing on it. And on Victoria's point about some of the suggestions that we've had put to us at various times, one that causes me concern is a desire from somebody with, they'll always have a very loud voice, but I would almost characterize, and it's come from multiple different directions, the idea that they want to put their board members up again on a block and have a run at them. And they just, they're not, I think we have to prepare a balanced process that's going to enable representation, it's going to enable support for your volunteers and protection for your volunteers. Because I think if we don't, it's putting downward pressure on reasonable people participating at the board level. And we need to put, much more we can do to encourage people to participate than it is to set them up just for abuse and harassment. And certainly, I don't know if anybody in the room has seen an uptick of that through the pandemic. I know we have, but wanting to make sure that managers and boards are treated reasonably.
All right, so I know there were a few questions. There was one intricate question about Bill 53. We will pass this on to the legal panel and the community and see if we can get those answers to you. We didn't get to all the questions. My apologies. We had limited time, and those online. Also, if you submitted questions, we will do that as well. I want to thank the panel, Todd Shipley, Victoria Archer, and Hugh Willis, not just for this evening, but really, when we talk about that last issue, it's easy to yell and scream and say, get this done. But the nuance that we need to take and the balance that we need to take to make sure we have something that's useful, this is what these three lawyers bring to the table and have influenced our government to bring back better legislation, not just loud legislation that won't meet the needs. And that's where CCI has that advantage, because we have such great volunteers with the expertise. So thank you to the three of you for this and everything for the past year. So thank you so much. Round of applause for our panel. And please do drive safe. Our meeting is, of course, adjourned. Drive safe, be careful. The roads are tough out there. And everybody online, thank you so much. Board of Directors, stay back for just a 2-minute meeting. We may conduct business right now or not. We'll see.
Not, but we do have to take care of a couple of things.